Hello, and thanks for joining us. I'm Josh Gingold, and this is how the Conduit Exception affects the HIPAA liability of cloud service providers. Brought to you by Ziff Davis and eFax Corporate, the world's #1 online fax brand. Our presenters today are Tim Dubes, Senior Manager of Enterprise Marketing at eFax Corporate. Hello, Tim. How are you?
Really good, Josh. Yourself?
Very good, thank you, and nice to have you here. We also have back for a second appearance HIPAA compliance instructor Ross Leo from training-HIPAA.net. Ross, welcome back.
Hey, thanks, Josh. How's it going?
Going very well, thank you. Nice to have you both here today. It goes without saying, but before we begin, I do want to add that the information provided in this presentation does not constitute and is no substitute for legal or other professional advice. We strongly encourage you to consult your own legal or other professional advisors for individualized guidance regarding the application of the law to your particular situations and in connection with any compliance-related concerns. Before we begin, a quick look at what we're going to be talking about for those of you who'd like a preview. We'll have a real quick introduction, and then we're going to talk specifically about the Conduit Exception to this new omnibus rule, which I'll introduce in just a moment. For those of you who aren't aware of it, I'm guessing that most of you are. Most importantly, we want to discuss the IT connection and why this is so important for particularly IT providers, cloud providers specifically. Bit of a reality check. What are the issues that you need to be aware of that aren't necessarily clear if you read that 500-plus page omnibus final rule document? We'll give you some examples, some really good examples actually. Good reason for having Tim in here today from eFax Corporate. And then Ross is going to cover some key points for providers and essential considerations. Obviously an issue that he deals with every day in his role as a compliance instructor. And then finally, we want to take as many of your questions as we can. Your comments are welcome as well. We'll save those for the end of the presentation. Those that we don't answer, we'll get back to most, if not all of them, via email. Another couple of quick instructions for you. First of all, the slides will advance automatically. As you can see, no need for you to do anything. Please just sit back, enjoy the presentation. Also, we do welcome all of your questions and comments, so you can begin submitting them now by simply clicking on the Q&A button at the bottom of your console. Enter your question and hit the submit button, and we will see those and get to as many as we can. And finally, there are a lot of related resources. Simply click on that resources button at the bottom of your console. You'll see a link to the past webinars that we've done on this topic, as well as the last in this multi-part series, which will be in just about a couple of weeks. So be sure to check those out too when you get a chance. In the meantime, let's talk a little bit about this new omnibus rule and what it means and why we're discussing this topic today. Among many other things that we have covered here in some detail, you know by now that the so-called omnibus rule of the Health Information Technology for Economic and Clinical Health, or HITECH Act, that is a mouthful, quote, makes business associates of covered entities directly liable for compliance with certain aspects of the Health Insurance Portability and Accountability Act, or HIPAA, the privacy and security rules of the requirements rather of that act. Now, it's very important for you to know because this is a change, one of the biggest changes actually, as part of this omnibus rule to affect HIPAA compliance issues in the past 15 years or so. And what that means for most businesses is that as a result, both covered entities such as healthcare providers, primary caregivers, etc., and their business associates, so the vendors that supply them with the services and products that they need to do their jobs as healthcare providers, must now have business associate agreements, or BAAs, which are formalized and legally binding documents where these entities acknowledge their responsibility for maintaining privacy and security standards as part of the provider's service. In other words, it isn't just your doctor or the hospital that's now responsible for keeping your information private, but it's also the folks that they work with that may also have access to your personal health or your protected health information, what is often referred to as PHI. Now, here's where it gets interesting for us today. A BAA, or Business Associate Agreement, is not required for organizations such as the U.S. Postal Service. I know that seems funny, but it's relevant, and you'll understand why in just a moment. Certain private couriers and their electronic equivalents, my emphasis, that act merely as conduits for protected health information, or PHI. Now, the reason that this is important, this is, in fact, part of this so-called conduit exception that we're going to be talking about today. You notice the key word in this last passage here, conduits. So these are essentially pass-throughs. Information is passing through certain systems, whether it's in a sealed envelope that a mail carrier is delivering to your home or office, or it's in a sealed box from a courier, or the electronic equivalent now, which may be, in many cases, organizations such as cloud service providers and software as a service providers, folks who really don't have access to that information. So this is, in fact, the conduit exception, and this is what we're going to be talking about today. So what is it and what is it not? Well, a conduit transports information but does not access it, as I said, other than on a random or infrequent basis as necessary for the performance of the transportation service or as required by law. Now, this is from the Department of Health and Human Services, so it all sounds very legal. We'll certainly clarify that as we go through this presentation, but clearly the point is that conduits are those delivering information without necessarily having access to it. Now, since no disclosure is intended by the covered entity or the primary care provider, and the probability of exposure of any particular protected health information, PHI, to a conduit is very small, a conduit is not a business associate of the covered entity, and this is where it's extremely important, because that essentially means that those conduits, when it's provable, and that would include some of these software as a service providers, that they in fact fall into this conduit exception. So what is IT connection, and why are we talking about this today? Why have we invited all of you onto this webinar? Well, the conduit exception applies directly to many of you. In other words, this is in fact the IT connection, and Ross and Tim are going to be able to provide a lot more detail on this. More and more IT services are available as online services. It's just a fact. And the trend is that we'll be going even further that way in the foreseeable future. And this includes transaction processing, enterprise resource planning, ERP, data storage, telephony services, and even faxing. And for those of you who wonder about faxing and wonder why we have Tim on here today from eFax Corporate, the reality is, of course, faxing is critical in healthcare environments. Still a technology that is extremely important, not only to healthcare, but also to the legal community. And for all intents and purposes, and you have to pardon the cliche, it may in fact be where the rubber meets the road. In addition to cloud service providers, of whom you already know a lot about. A lot of the big services out there that are hosting many of the services that we all use every day, and probably a lot of you. Now here's what's important about cloud services. Some cloud services do not require a business associate agreement because they also fall into the conduit exception, meaning they don't have ongoing access to protected health information, but rather act as the conduit, the courier, if you will, the deliverer of the data, this protected data. So when we talk about BAAs, however, as we've covered in past webinars, there are some realities that you need to understand, because we don't want to, by any means, as I said at the beginning, give you legal advice here. What we're trying to do is to provide the guidance that you need to make sure that you are HIPAA compliant and also understand what the facts are around these issues. So here's what I want to call a reality check, and this is where I'm going to bring my colleagues in, Tim and Ross, to comment. Of course, a lot of vendors want to participate in the lucrative healthcare market. Right now, obviously one of the biggest issues the federal government has mandated and incented hospitals, actually made it clear what their intention is, that they want to be able to control patient information, protected health information, and also other health service providers. They want them to move towards electronic patient records. Two different types of records here. There's EMR, or electronic medical records, and EHR, electronic health records. Nevertheless, they both have protected information in many cases. In addition, so here's all these folks trying to rush into this burgeoning marketplace for electronic patient records. The government is telling them to do so and providing incentives for them to do so. Oftentimes those incentives are actually less of a carrot and more of a stick in terms of compliance penalties for those both covered entities and business associates who are not compliant. The penalties are very strong. But many vendors have adopted policies to not sign a business associate agreement that providers require because they lack the legal expertise to understand the associated liability. Now, Ross, this is where I want to bring you in. Ross Leo from training-HIPAA.net. Ross is a compliance instructor, among many other things. And Ross, it's interesting, you were telling Tim and I a story just before the call began today about what an important issue this is, for instance, for cloud providers. And I just wonder if you can't give us a sense of what's at stake here and why this is an important issue. It's not as simple as just saying we want your business, hospital XYZ, therefore we're going to sign your agreement and be done with it.
Well, thanks, Josh. The issue with this particular thing is basically the same issue you have with any contract. It's always a two-way vehicle. You get something, but you have to assume something. In the past 10 days or so, I've gotten a lot of calls from clients. We've talked about this in class, what this actually means. And what I have to remind people of is that every time you look at a contract, which is what the business associate agreement is, it's a contract like any other, you're going to get something, a carrot, but you're also going to have to run the risk of getting a stick because the contract itself means you're going to be assuming liability. And the question that I always get is, what does that really mean to me? What's the liability that I have to assume? And my answer to them frequently is the liability that you're going to assume, you have to determine whether it's actually a correct thing for you to get. Can you reasonably expect to fulfill the liabilities that you're going to assume by signing the contract in the first place? And they go away and they think about it. And a lot of them are coming up with the very same question. Why should I do this? Do I really qualify? So we're dealing with this thing over and over and over the same way. And your point here, lack the legal expertise, a lot of their attorneys I'm finding aren't really sure about it either. So there is a tremendous amount of interest. And I always have to counsel caution. Make sure you understand what's at stake, what the risks are. And that's the biggest question. What risks are you exposing yourself to by assuming the liabilities and obligations of this agreement? And so they're all having to dig in really deep, and it's scaring a lot of folks.
Now, Tim Dubes from eFax Corporate. Tim, this next issue is really important. I want to ask you about this. The fact that other vendors are claiming compliance and offering BAAs as evidence of compliance when in reality they may not fully comprehend their services role in healthcare providers' overall practices and procedures. So in essence, if I understand this correctly, this is really an issue of providers who are not covered entities, but rather service providers who are essentially using BAAs as a bit of a marketing tool. And that's a problem as well because now the covered entities are entering into an agreement with a vendor that A, is potentially adding legal liability, and B, may not even be necessary and therefore adding additional complication to something that doesn't need to be that complicated.
Yeah, that's correct, Josh. And as Ross indicated, it's a two-way street. It is a legal agreement between two parties. So there isn't a concept of a blanket BAA, if you will, where you can, as a covered entity, breathe a sigh of relief and say, great, I've got it signed, no more worries on this. There are vendors who will use that and just say, what we found on the sales and marketing side is that prospective customers demand a BAA, so we created one. It may or may not have a lot of meaning, but they will offer it. They say, yep, we're compliant, here's your BAA. But it may not be applicable in every certain case. There are examples. Vendors may have certain services that are HIPAA compliant and other services that are not. And so it really gets down to that. You have to look at the individual situation, how you're using a particular application or service, and does the BAA really apply?
And this next point, you guys, and I think this is probably as important as anything for our audience to understand when we talk about a reality check, a business associate agreement does not transfer responsibility from you, the covered entity, the healthcare provider, to your vendor, the cloud service provider or whomever. It simply establishes a shared responsibility. Now, I would say anecdotally, and the folks that I've talked to in the past couple of weeks since we started this series, a lot of them, that's almost exactly what they're looking for. If they're using some sort of cloud service provider, and we all know the big ones, they feel that responsibility for that PHI, that protected health information, falls on that entity with whom they're contracting to handle that data. So to them, it's almost like hands up in the air, shrug of the shoulders, not my problem. That vendor is responsible for that data because it's on their servers. But I would ask both of you, Ross, I'll start with you. That's not necessarily the case, and this idea of shared responsibility is really what's important, and I think really sort of the spirit of the omnibus rule of the HITECH Act.
Well, it really even goes beyond that. What this slide says, that if the shared responsibility is absolutely true. However, there is something that's a lot more subtle in here that you really have to dig into the Act further to discern, and that is, if you look at the roles, the law looks at the covered entity as, well, for lack of a better way of saying it, as more or less the senior partner in this relationship, because it was always the BAA goes from the covered entity to the business associate. But because the risk of breach is what is being addressed here, at least in part, it is always the covered entity who takes the responsibility of having to report breaches, even if it wasn't a breach that occurred at the covered entity. If it occurs at the business associate, whoever they are, has to report it up the chain to the covered entity, and then they're the ones who do the public reporting to the Department of Health and Human Services, OCR. So you see, with that kind of a chain, they're the ones who are exposed in name if a breach happens, even if they weren't the ones that do it. So in a sense, yes, it's very definitely a shared responsibility, but there's a certain part of it that lands squarely on the covered entity. And it's a risk. But to be perfectly clear, nobody gets to transfer risk to someone else. Every individual entity, the business associate, the covered entity, even the subcontractors to the business associates, are all going to be held directly accountable under the law the way it's currently written for everything that happens on their watch or what is in their possession. So yes, your point here is that, but you've got to dig in even a little further to make sure that you know where the acts will ultimately fall in certain cases. And the covered entities that think they're going to transfer the responsibility to somebody else have got to look further because they can't do it.
And Tim, this is actually a really interesting point because when we talk about cloud providers particularly that don't want to sign these BAAs because they are verifiable conduits, the information is just passing through it, but there's a risk that they assume some liability by signing these agreements. Even if it is a shared responsibility, they've taken every step they can to, for example, as you're going to cover an example in the examples in a moment here, to make sure that they have protected the information that is passing through their conduit, right, through their service, whatever it may be. But by signing a BAA, they may in fact be assuming liability. If there is some sort of a breach, somebody prints an email that was sent to them via a fax service like your own, somebody prints that out or whatever the case may be, you don't want to be liable for that as a service provider.
Oh, that's correct. And it goes to something, that Ross indicated here, is you're not transferring responsibility, you're just adding another party that has some responsibility in that complete solution. So just because a vendor says their online service is HIPAA compliant, for the covered entity, that doesn't mean that their use of that service is HIPAA compliant. It may, the purpose of the business associate agreement is one where it says the covered entity is doing all that they can, or at least in this case, doing their due diligence to make sure that the information that they work with and share with their business associate still is being protected.
And let's get to those examples, because I think we're going to see that very clearly here. And I'm going to lean into you a bit, Tim, because this is an issue that is very close and dear to your heart at eFax Corporate, because you guys have to think about these things all the time. So we're going to take two examples, two usages of the same basic hosted fax service with one key difference, which is document archival. So we talked earlier about the fact that there is both this idea of data that's passing through a service and then data that is stored, for instance, on a cloud hosting provider. Fax is unique because it can go either of those two ways. So we start with the first example, and Tim, I'll ask you to comment. The first example is that the hosted fax service does not store faxes. It simply transports them from sender to receiver, certainly with transport layer security. TLS, that's Tim's note, and a very important one, or some other secure in-transit technology. So these are secured faxes, as secure as they can be, and there is no electronic archival involved with this service. Now, Tim, this is obviously very important, but there's one other distinction here. You can't go back a day, week, or month later and search for faxes sent or received by keyword. There is no electronic document repository. Tim, this is really, I guess, the big difference here, because this particular service would not fall under the conduit exception. And this is a really good graphic example of why we're talking about this topic today, because the conduit exception in this particular example, and the next example that we'll give is not the same, but this is clearly a case where eFax Corporate, for example, certainly doesn't want to sign a BAA and accept that legal liability.
Yeah, and Josh, there's really two things that people need to keep in mind about this. The concept of the PHI being secure in transit and being secure at rest. So in this example, and it's a very good one here, where we're talking about, you're on the Internet, the hosted fax service essentially is replacing what we would traditionally think of as faxing, whether that be from an individual fax machine, from a fax server that a healthcare provider may have on premises. This is an idea of truly being a conduit, of we're taking the document and transferring it through a conduit. In this case, it's both the analog phone lines as well as through the Internet. And it's being secure in transit, but that's still part of the conduit exception because it's not being stored. And it kind of goes back to that other issue that we talked about, that you may use this in a HIPAA compliant overall solution, but you wouldn't necessarily need a BAA from that cloud service provider because they're just acting as a conduit in this case.
Now, Ross, that's an important point. Two questions for you. First of all, and quick two-parter, and then I'll let you answer. But are there any red flags here that would make you think that this situation, this example, is not in fact a conduit exception? Number one, and number two, this issue of data in motion and data at rest. That's really what we're talking about with a lot of the web services as well, right? That is that if the data is secured through encryption or TLS, whatever the case may be, and is not at rest within the service, then certainly you want to know that that service is taking steps to protect against any sort of breach. But in fact, they would be a conduit exception, whether it's a fax service or any other service.
Well, to answer the first part, I think that this does qualify. The scenario that you've presented here does qualify as a conduit. Because, as Tim pointed out, the concept here, let me make this point. The idea here is that there is no possession. In other words, the service provider isn't actually taking possession of the data that's being transferred. And that would be the case with the post office as well, or the phone service, the phone company, common conduits. Because it simply goes from point A to point Z. It's passing through. There's no storage except the storage that is just part of the technology long enough to buffer it and all that sort of thing to get it where it's going. But as soon as it's arrived, it's gone. So there's the question of what sort of possession do these folks actually have. Second question is, even while it's in transit, what sort of access would they have? And as Tim points out, with the security that is placed on this, and the rules really basically say now, and they make it very clear, that encryption is what you have to use, because it's the only thing that really does deny access to unauthorized people, that with the access that they don't have because of the encrypted for data in transit, they would never have access to human readable anyway, because the customer who's using the service is the one that possesses the key, and the key is only good for the one transfer because the keys are refreshed and new keys are used with each successive transfer. So the other question of access, they're even denied access. So yes, I think that they very clearly would fall under the definition of the conduit exception here. Now, the fact that they cannot go back and archive, well, that's just the result of the fact that it's transferred from point A to point Z, from sender to receiver, and never stored any place or archived in any way. So I think that this whole scenario very definitely appears to qualify under the conduit exception. Now, did I get both parts of your question?
You sure did, and it
Okay.
leads us directly into example 2, which is the same service that offers an online storage function of the faxes that Ross just alluded to, that users can send, that the faxes that users send and receive, it would most likely not be subject to the conduit exception. In other words, it would require a BAA. And as a provider, you would need assurances from the vendor, which is within that business associate agreement, that access to those documents are secure. Now, this does not just affect fax, but I can think of web servers for copying machines in the office. I do this myself. I scan a document, I go to a web service, I pull a document down, which is similar in rough terms to how a fax might be handled. And that is clearly covered because there is an additional potential for a breach. And in fact, with encryption, as you pointed out, Ross, with encryption, those breaches really aren't possible while that data is in transit. But in this case, that data is in fact at rest and therefore accessible to somebody who's either smart enough or mischievous enough to go and find it.
Well, let's think about this even further. As Tim mentioned, there is the requirement also for data to be encrypted at rest so that it's protected there also. In other words, when it's not in the possession of whoever owns it or originates it, and it's anywhere else in the chain, it needs to be encrypted so that access to unauthorized people is denied. In this particular scenario, if they're going to act as a storage repository for faxes for a customer, you have to ask the question, whose responsibility is it to make sure that it's encrypted? Well, my experience is that the service provider needs to make available the service of encryption at rest for qualifying data, HIPAA-covered data. But it is the responsibility of the covered entity or the user of this service to ensure that it's done. The provider simply needs to make the service available. Is it their responsibility to encrypt it? No, because they're assuming a responsibility that is rightfully the covered entities. And I'll just simplify it by saying it's the covered entity's job to do it. That also means that the covered entity has got the key. But here it's the question of access, because now they are actually in possession. And part of what they do is provide technical support, and because this is a very large and not clearly defined thing, you may have a million different things you have to do to provide the technical support. It's reasonable to assume, and this is what the rule basically says, it's reasonable to assume that the provider of this service might actually need access to the data in a human-readable form to provide the technical support. So here, it's much more likely that a BAA really will be necessary to support that kind of activity because, as I say, it's reasonable to assume that they will need to. But let's not assume that they are responsible for everything. It's, again, as you pointed out earlier, it's a shared responsibility. But here it does qualify as needing a BAA.
And Tim, not only a BAA, but a service level agreement, which Ross just pointed out, and I imagine that this is something that your organization must deal with all the time, because although I believe you do fall into the conduit exception, certainly you still want to be able to provide some assurances, and in the case of this example, where service does not fall into this conduit exception, unlike your own service, not only do you want that BAA, as Ross points out, but you do need that service level agreement.
Sure, and it's important to point out here that the archiving is what makes the difference here, and you do cover that, things such as the encryption in the service level agreement and by extension the BAA. And the service, so in these two examples, we've done a very small change here. We're still, in one sense, being a conduit to send that document from one party to another. For example, a physician referral, or sending the patient's records onto another healthcare provider. But in part of this, once you store it, you're going to be subject to a BAA. In that case, then, for example, as a vendor, what I would do is I would look at the system that the covered entity is asking for, and I would say, we're not going for us to take on that liability of a BAA, we're not going to send the document as an email attachment, for example, because even with encryption, you can run into issues with that. Instead, what we're going to do is use encrypted storage. And then, for example, when you receive a fax as the covered entity, we're going to send you a message to the email, and you have to log in to a cloud-based service and then access that through password protection. That would be something that we'd be comfortable signing a BAA with. And in fact, that is something we do and offer as a secured service.
It almost sounds like, from what you're describing, Tim, and it's a great description, by the way, it almost sounds like that chain of possession that you see in so many legal cases, who had the evidence in their hands last, and who had it every step of the way. And that's really what you're talking about, is being able to ensure as a service provider, as an organization that might be covered by a BAA or any sort of regulatory compliance issues, you want to make sure that you're handing it off to a secure, verifiably secure location, so that you are in fact not liable, and you don't just cross your fingers and hope that that information doesn't fall into the wrong hands, even though to most people it would seem reasonably secure.
Correct, and I think that's a good way to put it. Sort of the way of, well, maybe this is a way to look at it. A lot of covered entities get into trouble because they'll make that assumption. We may work with a company and we can give them a service that is HIPAA compliant, and describe it in such ways like that, and how we store and encrypt the data at rest as well as in transit. But just because our service is HIPAA compliant, it doesn't mean that the system, that the covered entity, they may not be using it in a HIPAA compliant way. So there are some assurances with that, but it certainly gets a bit more complex when you look at the overall application of that service.
Okay, a couple of key points here, and I want to remind everybody that we're talking about how the conduit exception affects the HIPAA liability, particularly of cloud service providers. Our guests are Tim Dubes from eFax Corporate, and also Ross Leo, compliance trainer for HIPAA-training.net. Encourage you to check them out. Training-HIPAA.net. Encourage you guys to check them out. Also want to encourage you to ask questions and make comments as we come down the home stretch here. And I want to make a distinction here as we move into this next section, some key points for providers. Now in this case, I want to clarify, by providers I don't mean service providers. So we've been talking a lot about service providers throughout this presentation, and what I really mean here are actually healthcare providers, which would be those covered entities with whom, if you're a service provider, you would want to make sure that you have a BAA. So when we're talking about providers here, I really mean healthcare providers. here are some key points to remember as we move into what you really need to know about this conduit exception and how it's going to affect both your business, if you are one of these providers, or if you are a software as a service vendor, how it might affect you as well. First point is, as we alluded to, just because a vendor says their online service is HIPAA compliant doesn't make your use of that service HIPAA compliant. Now, Ross, I love this point because, again, HIPAA is a weasel word right now. It's a catchphrase that a lot of businesses are using for marketing reasons, and the reality is that they could put HIPAA compliant, and I'm not naming names, as you would say, or trying to say that there are companies that are nefarious enough to do this sort of thing, but it is possible, and I think that there are instances where terms such as HIPAA are overused for marketing purposes, but you can't count on that. If you go to a website because you're looking for some sort of service provider and it says that they're HIPAA compliant, you can't always count on that because according to Omnibus now, your use of that service isn't necessarily HIPAA compliant, or am I overcomplicating it?
No, you're absolutely right. I'll go back to the example I gave earlier. If in using eFax, for example, you're going to send a fax, it's an electronic message in the fax context, and the folks at eFax make available the encryption service, they're doing what they need to do. They're going to give you the service that you've paid for, and they're going to provide the features that you, on your own, are required under the law to do however you do it, whether you do it through eFax or some other way. But it's not their responsibility to make you do it. It's not their liability if the thing goes in the clear, if that's what you choose to do. So it really is on the healthcare provider, the covered entity, to employ the service that eFax has made available so that if there is a breach, is it eFax's fault? If they make the service available and you don't use it? No, it's yours, and the breach is yours because you had a service that could have fixed that, and you didn't use it. So your point is exactly on the mark. Just because they've made a service available that will satisfy the requirement, it really is your responsibility and liability if you don't to use it in a HIPAA-compliant way. Because they facilitated compliance, but it was you who chose not to be compliant.
Now, Tim,
and maybe I can add to that, Josh.
Sure.
And this may be an extreme example, but I think extreme examples often illustrate the point best. We take that example of the faxes being sent electronically, and they're getting an encrypted notification that they received a fax. They log into a secure portal, read the fax on their computer, and this is taking place at the healthcare provider. All of that's fine. We've signed a BAA, and we're offering a HIPAA-compliant service, but in practice, it may be a front office administrator who's in the waiting room has a 37-inch screen on their desktop, and that information is actually viewable and available to any patient that walks by. Again, an extreme case, but this is one where they're using a compliant solution in what would literally be a non-compliant manner.
And Tim, this next point, while I have you, because it's also related and very interesting, a vendor may offer a truly HIPAA-compliant solution and support that solution with the BAA, but that doesn't mean that your use of the service is HIPAA-compliant. And Tim, I would throw one example out there because you mentioned it. Let's say that and I'm going to pick on eFax for just a minute because it's easy to illustrate, so forgive me. But let's just say that you have the password-protected location for a user to receive notification that they've received a fax. They enter their password and go and retrieve that data. Everybody's happy. But if that person gives their password to somebody else and allows them to use their password to go and access that data that maybe they don't have the clearance or they're not actually a part of the organization, they're just trying to illustrate a point, whatever the case may be, that has nothing to do with the service that you provide. That is a HIPAA violation or omnibus violation on the part of the covered entity, the healthcare provider, for giving that password away. And that may not be a good example. I'm not a lawyer, forgive me, but hopefully you understand the spirit of what I'm saying.
Sure, and in fact, I would say your example was less extreme than mine because it's what happens every day. You're talking about HIPAA compliance in the process that they use, and we've certainly seen it in offices, right, where I've got 12 passwords for all these different systems, my EMR system, my CRM system. Now I've got one for my hosted fax service. So I put them on Post-it notes and attach them to my monitor, and that's how I follow them. Or I have an Excel spreadsheet with all my usernames and all my passwords, and I keep that available to me, or I share it with other people who need access to the service. That's the process that the covered entity uses, and that, yes, that would be a HIPAA violation.
And all I can say is, oh dear, on the Post-it notes. We've all seen that. That's a subject of a whole nother webcast, I think, just passwords in general. And the final, not the final point, but one other point, instead of sending or receiving documents to and from a personal productivity application like Microsoft Outlook, send encrypted notifications to an email address. Both Tim, both you and Ross have alluded to this. Ross, I would ask you, encrypted notifications such as what Tim has described seem to make an awful lot of sense. It does seem to provide a bit of defensible space for the providers to be able to say, we're taking every step we can to ensure that this information cannot be misused.
Well, I'd have to say that in cases like that, the encrypted notification, I would absolutely agree that whether that is perceived by some as being a belt and suspenders kind of an approach, I think it's very prudent for them to do that because it does show, and this is a point that's very important in the context of HIPAA and high-tech and omnibus, that whatever entity is in question, be it a business associate or covered entity, it's very important for them to consistently show due diligence. And a service like that, encrypted notification, is certainly a very shining example of continuing to show due diligence, that they're aware, that they're taking positive action, that, gosh darn it, we're doing everything that we can do. I'm leading the horse to water, I'm putting the water in a cup for him, and all that kind of stuff. So, yes, I would agree that that's a very smart thing for a lot of good reasons for them to do, because they're making it very difficult for the user to violate HIPAA in the first place. But, just like the horse that won't drink after you've led him to water, it's not their responsibility to actually force the user to be compliant. But by giving them all the possible tools, by doing everything that they can do at virtually no cost to themselves, no complicating technology and that sort of thing that really is unreasonable, they're making it very difficult for anybody to point the finger at them and say, hey, you guys aren't doing everything that you should do. So I would agree that that's a smart thing to do.
And perfect segue to the final point here for covered entities when they start to consider HIPAA compliance issues and the conduit exception. Encryption is not, I repeat, is not specified as a requirement in HIPAA, high-tech, or the omnibus rule. Tim, I guess this is more of a best practice.
Yeah, and I think it gets down to that when you start to look at this, again, if it's going to be secure in transit, if it's going to be secure at rest, you can certainly secure the transport methodology, but even more so, encryption is just the best practice for this, and it shows that you've done your due diligence, and it certainly would help when you look at a HIPAA audit of the processes that you go through.
And Ross,
Josh,
you essentially
Josh, I got to interrupt you here for just a second.
Sure.
I have to throw you a curve on this. Actually, with the advent of high-tech and omnibus, it actually is a stated requirement now.
There you go. So much more, and I apologize, much more than a best practice, but actually a part of the omnibus final rule, so that the government, as we've said before, is using, in this particular case, this rule to tell providers, covered entities, exactly what they want. So I've misspoken here. It is, in fact, encryption is, in fact, a specific requirement of the omnibus rule.
Yes, it is, but But the thing that's very positive about that, though, is it takes away a question that a lot of people have had in their minds. Well, do I use encryption or do I use something else? Well, the fact is, technologically, there really isn't an alternative to it. But it also clears up something else, because a lot of complaints that I've heard when I go out and do consulting, in addition to what I hear in the classroom, they want to know something clear. As we talked about in our last session, HIPAA is not terribly prescriptive. It basically dumps it in your lap to say, do what you think is the best thing. Meet the compliance requirement, but do what you think is the best thing to do that. And it never came right out, because laws have to be technologically neutral. It didn't come right out and say, we want you to do this. So there was the laws of weasel words around the idea. And if you read it correctly, you've got, okay, they want me to encrypt. So in the final rule, they finally have come out and just said, here's what we want you to do. But that's a very positive thing, because it now makes very clear what you need to do. So whether you like encryption or not, whether you're afraid of it or not, at least it tells you straightforwardly and clearly what you need to do. So this is actually a very positive thing, that it does require it now, and it says so in so many words.
And
So,
Ross, I'd add, I would add to that when you look at most of the reported violations, it isn't so much even transit. It's usually because of devices that are lost or stolen that have unencrypted PHI on them.
Oh, you're absolutely right about that, Tim. Absolutely dead on with that.
And I stand corrected, and I apologize to our audience. In fact, and I appreciate the clarification, Ross, very much, and Tim, you as well. But perhaps this is a good thing in that it points out that this is, in fact, very important. And when you look at the Omnibus Final Rule in all of its glory, there is a lot of confusion and a lot of complexity, so worthwhile to discuss this particular issue. The reality is, I would argue, despite the fact that I'm wrong in this particular case, that encryption is, in fact, a part of the Omnibus rule. I would argue that the Omnibus requires it by default, because if you're not encrypting data that's in motion, in transit, then you're likely to be penalized, and the penalties are quite stringent, you don't want to be penalized for a HIPAA violation at this point. It can be very, very expensive. So that should be incentive enough, and I would argue, just to save face, that makes encryption a requirement right there, because if nothing else, it is by far the best practice to protect data from being intercepted and read by people who ought not be reading it. So I'll move on from that, and I want to thank you both for the correction. Go ahead, Ross.
Well, I was just going to say, I think you make a very, very valid point, though. Even in that, flavorful crow pie that you just very generously ate for yourself.
Yeah, right.
But to say that it's encryption by default, I think makes an important point. Once you've got the ability done, if you simply set it up to run, and encryption programs will run virtually automatically if you have them configured correctly, you take away what is a very large amount of worry in the points that you were making. So I think that your point about it being encryption by default, especially for data in transit, data at rest, and as Tim said, for those devices that are constantly lost or stolen, by making it the default setting, basically you make it possible for you to sleep better at night just routinely. So I think the points that both of you made on this are extremely important and very positive.
Well, thank you for that, and that was some tasty pie. But let's move on, because I do want to get to a couple of these questions if we have time. And again, I want to remind you, if we run out of time to take your questions, and Tom, Mark, Andrew, I see your questions in there. If we don't have time, then we'll answer those via email. We're very happy to have Tim Dubes here from eFax Corporate, and also Ross Leo from training-HIPAA.net. Thank you both. I want to wind it down, though, you guys, with some sort of final thoughts, some essential considerations, regardless of whether you are a covered entity or perhaps a business associate of a covered entity that would, in fact, be relying upon business associate agreements to remain HIPAA compliant. The first one is the role of BAAs. We talked about a moment ago, Tim, the fact that a BAA does not by any means absolve a covered entity from responsibility, but rather as a statement of both the covered entity and their business associates for shared responsibility. And that's really important here as we begin to wind down, to remind our viewers that this is not absolution. This is something you need to do to protect your business.
That's correct. It's a BAA is a contract, and a BAA is going to be, a well-considered vendor is going to look at that BAA as an agreement that is just as much, if not more so, part of their relationship with the covered entity as the service level agreement is, and they're only going to take on that responsibility if they truly have responsibility for coverage and access to that data.
And Ross, as somebody who spends, probably the majority of his life ensuring that your clients understand what it means to truly be HIPAA compliant, is it fair to say that your advice would be that the BAA is really only one part of that equation? We mentioned service level agreements, but there are also notification documents, et cetera. The BAA is not the end-all or be-all for HIPAA compliance via the omnibus rule.
I would agree. It is one aspect of a total relationship, but you can use the BAA to the point you're making in the slide. The role of the BAA, as Tim was saying, is to clarify who is supposed to do what and what the pluses and minuses are of each one of those things, and to use this as a regularly negotiated contract as part of a total business relationship. That's how they should be looked at, is to put on the shoulders of which party things that are justifiably and properly theirs. But it's a risk transfer as well as a risk absorption type of a vehicle, just like any other contract would be. So it just needs to be a standard part of all that and carefully negotiated.
And right along those lines, and thank you for just making this so easy for me today, you talk about it could also put you at risk. So when we talk about the applicability of the Conduit Exception, vendors, service providers who should not be signing BAAs, what's your position on this? Have you ever had a client come to you that perhaps fell into the Conduit Exception, and was there any point at which you put your hands up and said, hey, look, you really should not be doing this. You're burdening yourself with liability that doesn't belong to you?
I find myself in a position of having to give that kind of caution a lot more in recent weeks and months than I've had to before, because it is becoming a hotter topic. The one thing that I would have to say in my own defense, though, is DHHS OCR is on record as saying, and I've got quotes to this effect, that they say to covered entities, if you use a cloud services provider or a data center provider, you need to get a BAA. They're on record as saying it. So I can't counsel them to don't comply with the law because it's dumb. That's not responsible advice coming from me. But I think that what they need to do is they need to very carefully consider what it means to them, and if they feel it appropriate, they should correspond and say, we think we do. It's a law that gives you a lot of room to make your case and see if you can get an exception. And so that's the kind of advice that I give them. But it's absolutely one of those things that I counsel caution. Make sure that what you're assuming in the way of liability and responsibility is properly yours, and don't assume something that really isn't. And if you think that you're being forced into a pigeonhole, state your case and stand your ground. But in the end, you're going to have to comply with what the law says.
And Tim, that's a can of worms to some extent. And Ross, I appreciate that, and don't want to sound as if I'm disagreeing. But Tim, that's a can of worms, because if you're the entity that's trying to win that business from the hospital, and you kind of suck in your lip and say, yeah, no, we don't want to sign this, you may be at risk of losing that business because, quite frankly, there's so much uncertainty on the part of the covered entity, and they just want to play it safe, and they may be making a mistake, but you're the one that is not getting the business.
Well, that's true, but I would also say that's the responsibility of the business associate to educate on that. As we said, if you just offer BAAs as a vendor, as kind of a blanket, and you don't really understand what you're presenting to your customer, you are going to be sitting there hemming and hawing. However, if you're having a discussion with that prospect and say, let's understand what you're trying to accomplish with the solution, and then I can tell you at that point, we would, if you're using the service in that manner and you would like to do it that way, it would fall under the conduit exception. If you're looking for something that would be HIPAA compliant and fall under a BAA agreement, here's how we recommend using this service, and that's what we'd be comfortable with signing. So it is a more sophisticated discussion.
And I would recommend, because it is such a sophisticated discussion, and Tim, well answered, by the way, this is exactly why those of you who are watching this webinar want to contact somebody like training-HIPAA.net and Ross Leo's organization. They're certified HIPAA privacy security experts. They can help you with these really complex issues. And also look to your service provider. Make sure you're asking them the right questions. Final point here, Ross, before we let everyone go, documenting and validating adherence to HIPAA. This is probably not just with the BAA, but this is very important right now with the Omnibus Final Rule, is making sure that you are in fact compliant from a documentation standpoint, but also that that documentation is valid, that it'll hold up in court. And to Tim's point, it may be that a BAA that is not required could actually cause do more harm than good.
Oh, I would have to agree with your last statement. Having a BAA where in reality you probably shouldn't have one is going to be nothing but a thorn in your side. Maybe it's just going to sit out there and wait until something goes wrong, but it's always going to be a point of worry. When you document and validate your adherence to HIPAA, you need to do the homework, and you need to be in touch with what the requirements are. But that begs the question for you to go back and look at, if you're someone who is a service provider, it begs the question, do I really qualify under this definition or don't I? And you need to be fair and objective with yourself, because if you define it correctly, then you do have to question, why should I have to sign a BAA when I don't qualify? On the other hand, if you do, be fair and objective with yourself, and if you really do, you're avoiding responsibility and taking on liability to not. So you really have to be very careful, and you've got to, as you've pointed out several times, you've got to clearly understand what your requirements are, and do you meet certain definitions or don't you? Otherwise, you're asking for trouble one way, or by ignorance or blindness, you're asking for trouble the other way.
And Ross, with that, I'm going to give you the final word. Of course, that's Ross Leo, a certified compliance trainer for training-HIPAA.net. You can find them online very easily. Ross, thanks for all the information today.
You're very welcome. I think this is an extremely timely and important subject, and the more we discuss this, the clearer it's going to be, we hope. But certainly we've got to delve into this and get things clear for everybody.
We'll delve into it. We have, and you are certainly helping make it more clear. Also want to thank my colleague, Tim Dubes from eFax Corporate. Tim, thank you as well for all of the great insight and information today.
Oh, my pleasure, Josh. I really enjoyed the discussion.
Really enjoyed it as well. Now, clearly we don't have enough time for your questions today, but I'm going to answer those via email. Also want to encourage you to check out the related resources link at the button at the bottom of your console. There are links to a couple of webinars that we've done on related topics that I think will answer your HIPAA-related questions. We also have another event coming up, and there's a link there for that as well. You can send questions to me as well, webinars at ziffdavis.com. If you want to talk to Ross Leo or any of the folks at his organization, that is training-HIPAA.net. Make sure you use the www. As always, really appreciate all of your time, but unfortunately that's all we have time for today. Again, the information provided in this presentation does not constitute and is no substitute for legal or other professional advice. We strongly encourage you to consult your own legal or professional advisors for individualized guidance regarding the application of the law to your particular situations and in connection with any compliance-related concerns. I'm Josh Gingold on behalf of Tim Dubes, Ross Leo, and myself. Thanks for joining us, and we hope that you've enjoyed the presentation. This has been a special presentation of Ziff Davis, How the Conduit Exception Affects the HIPAA Liability of Cloud Service Providers, brought to you by eFax Corporate, the world's #1 online fax brand. Thanks for joining us, and have a nice day.